everyone. Thank you so much for joining us here on this lovely Thursday afternoon. Morning. Can you believe it? But thank you for being here. Thank you for attending. We had a huge registration turnout for this. So it's obviously that there's a lot of questions around how to properly consider your body corporate rules. And we are hoping that Zerlinda, well, definitely she will be able to answer a lot of those questions today. So as we normally say, please go ahead and put your questions into the Q&A or into the chat. As we go through, we'll see if we can answer them as we're going through. If we can't get to any of the questions, we will answer them after the fact and then send it to everyone so you can have your answers. We're seeing, as I said, a lot of questions about this in the sectional title living in SA and on those other Facebook groups. So I think without further ado, let me introduce our speakers for today. So as you know, we've got Willie Roos here today, who's the CEO of Stratafin. He has a wealth of experience in property and as an attorney, being involved in sectional title management for over 8 years. He started Stratafin in 2012 with the goal of assisting bodies corporates and with their funding without catching them in a debt trap. Willie will speak a little bit more about Stratafin at the end of the webinar, and there'll be a nice discussion between Zerlinda and Willie during the webinar about some of the questions that have come through prior to this webinar. So we're really excited about that. And then we've got Zerlinda van der Merwe here today with a wealth of experience on this particular topic. And I don't think we could have gotten a better person in here today to talk to us about body corporate rules. She actually did her master's thesis on body corporate rules, correct, Zerlinda?
That's correct.
Great. Okay, so I'm sure most of you know who Zerlinda is already, but if you don't, Zerlinda is a specialist community schemes legal consultant, offering the services of legal advice in the form of consultations and legal opinions, meetings and CSOS attendances, government governance, documentation review, and amendments. And she is also a professional trustee. She is an owner and a resident in an HOA and an investor owning in sectional title schemes. So again, she has a wealth of experience about everything about HOAs and sectional title. So what I did want to ask is that we've now told you a little bit about ourselves. I wanted to ask everyone a little bit about themselves. So I'm going to put a poll up on the screen, if you wouldn't mind just answering it, as to whether you are a trustee, an owner, or a managing agent, or any combination of those. So if you could just answer that quickly, we'll be on our way after that. Okay, perfect. So I think we've got a nice amount of people that have answered now. So I'm going to close off the poll, but I like to see that we've got a lot of managing agents, a lot of trustees in here. So thank you so much for answering that. And then we'll carry on. Zerlinda, over to you.
Fantastic. Firstly, thank you so much to Willie and Daniela for your invitation. I was talking to Willie and Daniela that I met for the first time physically during the course of last week at the NAMA Bowls Day in Cape Town. For those of you that live in Cape Town that didn't attend it, naughty, you should have been there. It was really great. And Stratafin went all out. Not only did they have non-children friendly blue slushies, that looked to be very, very popular, they also really, really went all out on their outfit, and they won the funkiest outfits. And I think you would have won the funkiest hats as well if it wasn't terrible that we would give you two prizes. So I think that was fantastic to actually physically see you there. Daniela is such a petite young lady. She's much smaller than one would think, but she comes across fantastic in stature. And Willie is a heck of a lot taller than I thought that he was going to be as well. So it was lovely to meet them, to see the people behind the computer screens. But Stratafin has always assisted us and always supported us and always given us so many fantastic opportunities to work with their client base and their database. So this is just another one of those, and I thank you very much for that. All right, so today we're going to talk about my favorite topic, which is rules. Title schemes. We can obviously deal with any questions that you have in a homeowners association as well. And something that I would like to point out right at the get-go is that when it comes to sectional title conduct and management rules, you need to submit it to the Community Scheme Ombuds Service for their review and approval. But when it comes to homeowners association constitutions, memorandums, and rules, be it conduct, state rules or architectural guidelines, or you name it, those do not have to be submitted to the Community Scheme Ombuds Service for review and approval. What they do, however, is that they're quality assured, which means that you can submit it to them for their inputs, but you don't have to take those amendments on board. You don't have to get a certificate of approval from them at all. And of course, because they deal with dispute resolution, it would be a good idea to take those comments on board in case somebody does challenge the validity of your governance document. So that's just a little forefront. I like to tell my clients that when they come to us with regards to amendments of management rules and conduct rules, that it is a working document. I very often attend annual general meetings where the members say, you know, let's change the managing agent, let's change the auditor, let's change whatever. You know, they should have the same type of mentality with regards to the rules, because the rules have to be suitable to the scheme, and it has to be suitable to the owners, the occupiers, being, you know, whoever resides in the unit, tenants. It must be suitable to the needs of the scheme. And, you know, working with a set of rules that perhaps were drafted under the 1971 Act, you know, it's not going to be suitable to a scheme of today. And of course, we know that if you amended your rules under the previous two statutes, then those rules continue under the Sectional Title Schemes Management Act, so long as they're not in conflict with it. There's been so many amendments over the years, especially from the Sectional Titles Act to the Sectional Title Schemes Management Act, let alone the Community Scheme Ombuds Service Act, that it is a very good idea to look at the amendment of your rules. You obviously don't want to do it just for the sake of it, and I would never recommend, you know, going through the whole rigmarole of getting a special general meeting, getting a special unanimous resolution, the quorum being the most challenging part of it, if you're just going to amend a rule. So perhaps what trustees could do is, throughout the course of their year in the position as trustees, is just to make notes of some of the things that they found challenging, you know, perhaps rule enforcement, the imposition of fines. They can attend webinars and seminars and listen to what other body corporates are doing, speak to other trustees, speak to their managing agent, hear what the managing agent is doing in other schemes, to see whether or not there is a need to amend their rules. We have been getting quite a few requests for amendments of rules, and it all starts off with the amendment of the legislation, which did take a while for members to really wrap their heads around, but it leads into what we like to say as the rules being a working and a living, breathing document that you actually need to work on constantly. Now, I did mention that as your occupation changes, of course, the needs of the scheme change as well. So you might one year have residents with absolutely no pets, and the next year suddenly all the new owners and occupiers start moving in with pets, and pets become an issue, and pets have never ever been an issue before. So you need to have a look at that rules. You need to see what are the needs of your scheme. Very often trustees or members are wanting to change rules to suit them. They want certain items, for example, they want fines to be raised, or they want the owner to be responsible for maintenance of common property, but it's not necessarily something that the body corporate needs. So it's very important to first have a look at what your scheme needs in terms of regulation and guidance before you look at what the scheme desires or what the members would like, because very often what you would like or what you want is not necessarily in line with the legislation or in line with what the Community Scheme Ombuds Service will actually accept, and we'll deal with that in a couple of minutes. Very often the opportunity does present itself for the amendment of rules. I often consult with clients and they say, oh, you know what, we've got a special general meeting coming up for the creation of exclusive use areas. So while we need to amend our rules for the purpose of that, why don't we just look at our fining rule that we've had a problem with for the last 10 years, or let's have a look at our parking rule or something along those lines. So very often the opportunity does present itself. Perhaps you've got your annual general meeting coming up and you know that the annual general meeting, all intents and purposes, is the better attended meeting, although that's not really, it doesn't really say much because we do tend to struggle to get a quorum. You could potentially then work on the rule project to have tabled at annual general meeting. And I'd like to chat to you about passing rules at an annual general meeting versus a special general meeting, which I'll do in a couple of minutes. Another big thing that comes up very often in our consultations is where the developer has been involved previously and no longer is involved, or the developer is involved beyond the point that the members feel comfortable with having the developer involved. I like to think of the development period as being a bit of a honeymoon period, and then of course the divorce hits when the members and the developer no longer get on and there's irreconcilable differences and they want the developer to pack their bags and move on out. And very often schemes are, or they have rules in place that suit the developer. And Willie and I were chatting before the webinar started about having very unique and particular rules in place in a scheme where they could be subject to challenge later on, or circumstances change and an owner now needs to deviate away from the rules. And we spoke about the validity of the rules in regard to how those rules are set up. But I don't know if you maybe want to raise that question of the retirement development at this point in time, and we can chat about that.
Yeah, a particular question that came up was people that were staying in a retirement home, sectional title scheme, and there is a requirement that people need to be over 50 years of age to be resident in the scheme. And the example that we used was a mother that passed away then. The grandparents stay in that scheme, and the grandparents are the only living relatives of this 14-year-old girl. And can she now live in the scheme that has a specific rule that specifically states that people need to be over 55 years of age? And what are your rights in that respect? So I think that was quite an interesting question that came along.
Definitely. And, you know, how it ties in here with the whole reference to the development period or the developer is that the Sectional Titles Act previously and the Sectional Title Schemes Management Act now provides that certain management rules can and cannot be amended by the developer prior to the establishment of the body corporate. Of course, once the body is established and there are members representing more than 30% of the units, the members can change either the conduct rules or the management rules. But the developer at the beginning has to do it very in a very correct manner in order for it to be valid and binding later on. And that question that was posed about the retirement scheme is such a fantastic example, because if you had to put in your management rule, for example, and this is, you know, that type of rule would need to be in the management rules because it's a restriction on your rights of ownership. If that had to be submitted to the community scheme ombuds service in a normal scheme, they would say, you know, that's an unconstitutional infringement, you know, that is a discrimination on the basis of age. Whereas the developer would need to ensure that when setting up that type of development with a retirement element, that they amend the management rules in such a manner that they actually create an overarching association with the constitution, and that constitution will then take the place of the management rules for the developer to actually legally be able to put that type of restriction in place. In other words, the age limitation. That type of restriction would then not only be in the management rules, but it would be a title deed restriction, and that would mean that it would not be subject to challenge through the community scheme ombuds service. And it's something that every single person knows and acknowledges when they buy into the scheme, higher than a management rule. So in that specific scenario of yours, you know, despite the fact that it sounds terribly heartless that the 14-year-old, you know, teenager is not allowed to go and live with the grandparents, that scheme has been set up for the sole purpose of being a retirement development for a certain age group with certain requirements and certain needs. And by allowing, you know, in this instance, one, but perhaps more children or teenagers or younger people, people with a different interest, people with different desires in the scheme, you know, that is flying in the face of the nature of the scheme and the intention that the developer had in developing it. So a rule like that would need to be done properly in order for it actually to be enforceable. but that's a very good question. I think that they would need to uphold that rule, and that person would not be able to go and live in the scheme. But it would be interesting to see if something like that would go to the community scheme ombuds service and what the adjudicator appointed would actually say in that specific matter.
So you also mentioned in the USA, for example, where schemes are set up for specific purposes, and maybe that's an interesting thing to mention at this stage as well then.
Yeah. So when I was doing my master's on the constitutionality of rules, I had to compare the South African legislation to foreign jurisdiction, and one of the countries that I looked at was USA. And in America, in their condominium systems, and there they have like sectional title and like homeowners associations, a lot of Gulf states, especially in Florida. They've actually got associations or complexes for specific criteria of people. So they've got complexes perhaps where women have been abused previously and they need to be in a community where they feel safe. So, single moms and their young children that come from a really bad background into this community where they are offered, like therapy and protection and all that fun things. Or you would get a community where there are only, men or only women, or, communities where only young children are allowed, obviously with their parents. So there's so many different unique types of condominiums that are there. And of course, their legislative framework allows for that. In South Africa, with our constitution, we would struggle to have any type of community like that. I'd be very interested to see if a developer would do that. But that led to our discussion as well about the issue of pets. So we know that there's been foreign legislation, and Prof. Van der Merwe and Prof. Paddock have put out articles about the keeping of pets in schemes. And we were discussing whether or not body corporates could amend their conduct rules to not allow pets. And some of the things that we were chatting about was that if the scheme does not lend itself to the keeping of pets at all, it would be reasonable to have a conduct rule that says, bearing in mind that if you have a guide, hearing, or assistance dog, that needs to be allowed, and there's no application that is needed to be given in that specific scenario. So that's another, good talk about these things all day. Something that comes up very often in our consultant practice is exclusive use areas. And I was in a consultation yesterday or the day before where the client said to me that the gardens must be exclusive use areas because there's a wall. And I said to them that just because, just because there's a wall around it and a gate or nobody else can access it doesn't make it an exclusive use area. An exclusive use area is only an exclusive use area if it is registered on the title deed and in the sectional plans, or and relevant to this specific topic, in the management rules or the conduct rules, bearing in mind that you could have an exclusive use area in the management rules and in the conduct rules, provided that you don't have the same exclusive use area in both the conduct and the management rules. And if you're wanting to take it out of the management rules and put it in the conduct rules or vice versa, you would actually need to change that set of rules. So for example, if you had it in the management rules and you're wanting to make it easier later on and put in the conduct rules, you'll need a unanimous resolution to change the management rules, take it out, and a special resolution to put it in the conduct rules. Another thing about exclusive use areas is that it's not good enough simply to refer to the exclusive use area in conduct or management rules. You actually need to create and allocate it. And that means that you need a layout plan showing exactly where those exclusive use areas are, indicating what they are as well, gardens, parking bays, etc., etc. And you need a schedule of allocation. That schedule of allocation mustn't be allocating the exclusive use areas to a specific person, because obviously you can sell and move on and the person can change, but actually linked to a specific section. Something that Prof. Paddock taught me years ago is that essentially you could have one exclusive use area that is allocated to multiple sections. I've never actually dealt with it in practice, but legally it is possible to have that. So that's something interesting to keep at the back of your mind. I don't know, Willie and Daniela, when it comes to levy matters, I'm sure that you very often have a question posed in regard to exclusive use area contributions and whether or not in terms of the rules you can actually change that to make an owner directly responsible for their exclusive use area maintenance and repair work as opposed to paying a contribution. I know that question comes up very often in our Facebook groups as well.
Yeah, we've had that, but luckily we've not had that as a defense in a matter that's gone to court. So luckily not. Zerlinda, a very interesting question by Aubrey. Hi, Aubrey, I see you here. Aubrey is an old friend of ours. He also does some webinars with us. And that is the limitation of period for a trustee to stand as a trustee so limiting a trustee for example for 2 terms or 3 terms, so that we can get more trustees in. And obviously it has the other advantage that you can make sure that the trustees are not building up interests in the body corporate, and it's fair and transparent, and they fulfill their fiduciary duties. So that's also a very interesting question.
Definitely. You would need to amend your management rules to allow for that. And just to go back to the developer issue again, very often we get requested by conveyancer clients or developer clients to actually amend the management rules to provide for a certain number of trustees and for the period that they are entitled to be trustees. And sometimes even that the developer or the developer's representative is the chairperson, or that the developer has the majority interest on the trustee committee as well. So you can definitely do all those sorts of things, that you just need to amend your management rules accordingly.
Zerlinda, just before we move on, I saw there was another
the
question
and repair
here.
of the exclusive use area.
Sorry, Zerlinda.
Yeah.
Diane Vosloo just asked, what is the difference between management and conduct rules?
Sure, it's a question we get often. So it's a pretty simple answer. If anybody's got a more legal answer or a more comprehensive answer, they're more than welcome to chime in. But a management rule deals with management issues, and a conduct rule deals with conduct issues or behavior issues. And the Community Scheme Ombud Service actually says that you cannot have management issues in the conduct rules and conduct issues in the management rule. And when we meet with clients, they often say to us, you know, nobody ever reads the management rules. Everyone always reads the conduct rules. So we should actually slot in a couple of these management issues in the conduct rules. For example, to say that the body corporate has the right to recover legal fees. And that's one of our bugbears between Willie and myself. Or the body corporate must say in their conduct rules that levies are due and payable on the 1st of the month, and that you'll get handed over on day 7, for example. But you can't have the two interchangeably in each other's rules. You need to keep it separate. Willie, I don't know if you want to jump in on that whole legal fees issue with regards to the management rules.
Yeah, I think we've been over that so many times. We believe that that the owner that is in arrears should actually pay all legal fees and all expenses in respect of the recovery of the debt, where the new rule now requires that it must be taxed or agreed. Obviously, nobody will ever agree to fees, so you will have to tax it. There's a huge difference between the tax cost and the real cost of collection. The tax cost is maybe a quarter of what you would really pay in respect of the recovery of that debt. So that means that other owners become liable for 3/4 of the cost if they go through a law firm to collect it. Obviously, there are people that say no, but make use of CSOS, but obviously the CSOS process at this stage is very limited in that an order is granted, and that order then has to be made an order of court, and then you follow the normal recovery process through the courts of law. So even if you follow the CSOS process for recovery, at some stage you will go to court and somebody needs to pay for that. And at the moment, other owners or owners that are compliant are paying for the cost of collection, which we believe is completely unfair and should never be like that. CSOS, however, has a different point of view in that regard. I mean, we've discussed the changing of rules to then bring in the old rules. I think it was 25 or 30 or 31, the old rule it was. So bring back the old rule 31. But from Jolene's point of view, it seems as if CSOS is not going to allow it. We've not seen that they have allowed it. I don't know if you guys have seen Zerlinda, but from our side, we've not seen it allowed or disallowed. They're pending, so we don't know what is the outcome going to be in that respect.
So we'll still fight it until the death, because I do believe that you should be able to change your management rules, bearing in mind that the person that is in arrears that has to pay the legal cost needs to vote in favor of that unanimous resolution as well. So you're not even going to get the unanimous resolution, let alone actually get to the CSOS for them to review and approve it. But we'll chat about that as well. Just to go back to when to look at amending your rules. There's also a lot of times where the issue of enforcement is a problem, and I know that was one of main topics that we wanted to discuss today was, how do you actually end up enforcing the rules? And, South African legislation has been seen as toothless legislation. In other words, it's all good and well to have the rules, but you're not actually applying it, or you can't apply it. And unfortunately, whenever I think of the word draconian, I think of my time at BBM with Marina Constance, and she always said she doesn't want rules to create an environment of a community that is draconian. In other words, people are too scared to do anything because they fear are simply going to fine them left, right, and center. But we know, other than fines, we don't really have much enforcement in sectional title. We do have the community scheme ombuds service now, but you do first have to follow a whole bunch of internal steps before you can even make an application there. So very often fines is very much needed in rules. And if a body corporate doesn't have fines in their conduct rules, they use that as an opportunity of actually changing their conduct rules.
Zerlinda, just on the topic of fines, we have one question here from Annie who says, can we have immediate fines for the biggest problems in a complex? Noise, things on balconies, parking, etc.
So I know that you will share the practice directive along with these slides and the recording of the presentation. I think members that are in attendance today, I'm just going to have a look at them if they haven't yet done so. With regards to the fining rule, we always used to put a summary fine in place. And, an example of a good time to issue a summary fine is for parking. Unfortunately, the community scheme ombuds service does not want summary fines to be raised. They want there to be a process of a warning and a due process of review. So you can raise a fine for a contravention, but then allow the owner or the occupier to come and speak to the trustees or correspond with the trustees to look at actually reversing that fine or diminishing that fine. And when it comes to summary fines, in other words, you are parking in the wrong spot right now, we're going to issue you with a fine, the CSOS is not in favor of that. That being said, it does need to go to challenge, and very often people are going to say, oh, I got a $500 fine for parking illegally. It's going to cost me 6 months of my time to deal with it at the CSOS. I'm actually not going to fight it. So a lot of body corporates still do have that summary fine in place. Whether or not it's illegal is subject to debate.
Yeah, I think in a constitutional democracy where one of our rights is the right to fair representation and the audi alteram partem rule, where your side can be heard as well, or should be heard, I think we're moving away from where people can just be fined or something can just be done without you having recourse to putting your side of the matter as well, because there could have been an emergency or whatever the situation might have been, that you had to park at that specific parking and so forth. So you need to have the right to a reply. And I think that's always been a legal principle in the courts, and I think that is now being applied in schemes as well.
Yeah, and it's a good example that you used there about the parking. It might have been an emergency or something. In our conduct rules, when we drafted for parking in vehicles, we actually say, don't park on common property unless you're parking in a visitor's parking, etc., except in the case of an emergency. So if you quickly had to, park your car in front of somebody's garage because you're needing to carry somebody down to rush them to the hospital, that's an emergency. You have to be reasonable in those circumstances. Of course, you need to deal with it on a case-by-case basis, but your rules need to cater for the eventuality of something happening that, although it's in breach of the rules, there's a good reason behind it. So that was a very, very good example.
There was a question, can you impose fines if your rules does not allow for it? So that obviously is the answer is no. I mean, you can't just go and make up fines as you please. I mean, you will have to change your rules to make provision for that.
Perfect. Yes, yeah. A colleague of mine years and years ago was dealing with a levy collection matter, actually, up your alley, and there were fines raised on the levy account. And when we looked at the rules, we saw that there wasn't a fining rule in place. And the attorney came back to say that there's a provision in the Act that says the trustees can do all things reasonably possible or that they're reasonably able to do. Yes, necessary, that one. So he used this catch-all provision to say it is necessary for us to enforce to have a fine, so therefore we're going to raise a fine. I thought that was a fantastic argument. Obviously it didn't win, but that is one way of looking at it, that we don't have the rule in place, so let's see what provision of the Act could possibly be used in our favor. But you're quite right, you have to have a rule relating to fining in order to raise a fine. Correct. The change of legislation, when the legislation changed, everybody jumped on the bandwagon to actually deal with amendments to the rules. We saw with Poppy and Paya coming into place, a lot of people contacted us to amend their rules as well. So even with COVID, a lot of people came to ask us to amend their rules. So it all depends on what's going on at the time. If there's an amendment to the legislation, that would result in the amendment of rules as well. I can only imagine that when the STSMA gets amended, there is going to be so many amendments that we're all going to be kept busy for days and days and days dealing with the amendments to rules. CSOS compliance. So very often you have to amend your rules to ensure that the CSOS practice directives are adhered to. And like I said, you're going to have a look at that afterwards. And then, of course, if members request that there be amendments to the rules, 25% of the members call a SGM, direct the trustees, or at an AGM, an ordinary resolution is passed to direct the trustees to have a look at the rules. That's the time that the rules get amended. Daniela?
Zerlinda, we've got a couple of questions here on the topic of CSOS. So I wanted to wait until you got to CSOS compliance to start chatting about that. Sine Graham, she says here, can you please assist with advising which documents must be submitted to CSOS when conduct rules are approved by round robin?
Perfect. So I'll jump to that slide, no problem, because we can talk about this interchangeably. When the rules have been approved by the members, either a special resolution or unanimous resolution, you need to download a Form B. A Form B basically looks like the old Form V. It's essentially a trustee resolution. I also like to have a trustee resolution supporting the special resolution, as well as a special resolution or unanimous resolution. So a whole pile of documents to submit to the Community Scheme Ombuds Service. And that form needs to be supported by a signed copy of the minutes of the AGM or the SGM where the rules were amended. Now, I also had this discussion just before the webinar started about, that an AGM minutes or SGM minutes is only approved and signed by the chairperson at the next meeting. But the Community Scheme Ombuds Service, within 10 days of the resolution being passed, wants the rules to be submitted to them with a copy of the signed minutes of the meeting where the rules were discussed and passed. So what I like to do is actually sign a trustee resolution or propose a trustee resolution where the trustees note that the minutes are being signed in their draft format, that the trustees don't for approving the rules when the members have not yet approved them. Nicole also very often reminds me that the CSOS won't even entertain looking at a set of rules unless the scheme is registered. So although there's no practice directive that says that, you have to have your body corporate registered before you can submit the rules to them for review and approval. So that's quite an interesting one. And I know there's a lot of sectional title schemes that are not yet registered or they're waiting for their registration number. So that's a biggie. The rules also have to be submitted in a consolidated format. This is something that a lot of people are not able to understand, but basically it doesn't mean the management rules and the conduct rules must be in one document. It means that all of the amendments over time to either the management rule or the conduct rule must be in one document and submitted to the Community Scheme Ombuds Service. So if we're just amending our short-term letting rule, we can't just submit that to the CSOS. We have to put the short-term letting rule into the conduct or the management rules that we're amending, as well as any amendment that we have made over the last 10, 20, 50 years, and submit that to the Community Scheme Ombuds Service. Of course, you are then running the risk that they're going to review your entire set of rules and then come back with comments on rules that have been amended, 20 years ago. But when you submit it to them, you point out which rules have just been amended, or the special resolution or the minutes of the meeting specifically note that. So that's the documents that are needed for that question, Daniela.
Fantastic, thank you. One more question while we're on the topic of CSOS. Nicolene writes, read your comment about HOA rules being submitted to CSOS. There is now CSOS Form B1, which you were just chatting about, which states it is for amending rules of HOA and share block companies. So is this not a requirement to submit when rules are changed by an HOA?
So if you have a look at the practice directive that was presented by Jolene a couple of months ago, she specifically notes that it is not a legal requirement for homeowners association rules or governance documents to be submitted to them. But what they've done to make it easier for the industry, obviously the CSOS is there to offer as many services to communities as they're possibly able to do and to assist in all regards. They will quality assure documents, and that literally just means that they're reviewing it and giving you tips and tricks, very often in line sectional title legislation that may or may not be relevant to your homeowners association practically, obviously not legally, and they will then obviously protect the homeowners association against any particular issue that might go on dispute to the CSOS. Because although the CSOS doesn't review and approve your rules, they can most certainly deal with a challenge as the legality of them as part of their dispute resolution process.
Perfect. Thank you, Zerlinda.
No worries. While we're on this slide, I think let's chat about the timelines, and I'd be very interested for people to post in the comments as to their experiences in regards to the amendment of the rules and how long it takes. In our experience, new schemes, in other words, the rules that are submitted by a conveyancer or developer, go quite quickly. Existing schemes take a bit longer. I consulted with the client last week, and they mentioned that it took 2 weeks exactly for the Community Scheme Ombuds Service to come back to them for the approval of their rules. And I know, Willie, there's been quite a few comments on those sectional title groups on Facebook that the CSOS is ramping it up when it comes to rules that are submitted. In our online, she can comment as well. We tend to find that the rules that we've been submitting of late gets a quick turnaround time, but the ones that we submitted like last year or the year before, we're still following up on. So it's almost like the CSOS has said, from today, we're going to work very quickly, but everything before that is taking a longer. So I'd be interested to hear, people's experience in regard to the timeline of the amendment. We get asked to follow up very, very often. And, Jolene has made herself available time and time again to follow up with her relevant role players in the different offices. You also need to, make sure that you're following up with the right people because you can get, shifted around to quite a few different people. So when in doubt, contact Jolene or contact your provincial ombuds as well. I know in the Western Cape, we're extremely fortunate to have Malitsatsi. Her email must literally bomb out at least once a week with all the emails that she gets copied into, but she always replies, Jolene as well. So if you're stuck and you're needing an update on your rules, you can more than happily contact them. So that's the timeline issue. Just to go back to the previous slide, how to amend your rules. The question earlier mentioned round robin resolution. So that's one of the ways that you can amend it. Obviously, it can be done at a special general meeting called for that purpose. It can be done at an annual general meeting. It can be done via round robin, in other words, in writing. And very often, especially during COVID time, a lot of resolutions have been taken via round robin. It's important to note, however, that if you're going to pass an amendment of the rules at an annual general meeting, that must be called on 30 days notice and not 14, because you're dealing with special business, special unanimous resolution. And of course, and this is something that my colleague Ruth Grunder at Pam Golding will fight me on, but when it comes to the delivery of notices, I'm of the opinion, and supported by a couple of other guys in the industry, that when you're dealing with special business, special unanimous resolutions, the notice must be sent via prepaid registered mail or hand delivered and emailed. The emailing is, secondary. It has to be sent via prepaid registered mail or hand delivery first and foremost. When it comes to a bog standard AGM, where ordinary business is going to be dealt with, or a special general meeting where only ordinary email is sufficient, provided the person has in writing notified the body corporate that the email address is the service. Philly, I saw you unmuted yourself. I hope you agree and not disagree.
No, I agree with you. We've just on the group Sectional Title Living South Africa, we saw that people are now starting to send out these notices via WhatsApp. So technology is moving, but unfortunately the legislation is not moving as yet.
Right.
So it is a problem, and that is something that CSOS will have to address, because we are getting to the age where we are communicating in an electronic way. If you send stuff out by registered mail, the probability that somebody is going to receive it is far less than when you send it out via WhatsApp or via email. But unfortunately, the law is what the law is. So you're absolutely right.
Yeah, we get asked often whether or not we can change the management rules to actually provide that notices can be emailed only, but we need to remember that it's actually a provision of the Act.
Yeah.
Section 6 of the Sectional Title Schemes Management Act that deals with that. When I used to be a managing agent, we would send our notices out by prepaid registered mail, and 2 months, 3 months later, our messenger would come back from the post box with literally like 90% of the notices sent back again of people that are not collecting it. And it used to break our hearts to see all of those notices being returned. Or you get to the meeting when we still had physical meetings, and the person very politely zips open the envelope and starts looking at the pack at the meeting, as opposed to 30 days before when it was Or worst case is arriving at the meeting without their hard copy pack that was emailed and posted to them and asks for a copy. I remember our portfolio managers used to print for days to have extra copies at meetings. So the nice thing about having remote attendant meetings is that we don't have all that wastage of paper other than the ones that actually have to go out for the purpose of compliance. A managing agent client of mine invited me to a special general meeting, and on the day of the meeting, literally like 2 hours before, they confirmed that an owner had said, hey, I didn't receive my notice via prepaid registered mail, and it turns out that they hadn't sent it that way, and they decided to rather call the meeting off, which was the correct thing to do. But something as small as that can invalidate a meeting, unless, of course, a reasonable attempt has been made to get the notice to people. But if you just don't send it, that's not a reasonable attempt to comply, not at all. So there is definitely still a lot of red tape that we have to comply with when it comes to special unanimous resolutions. Another thing that people very often do is that they send the notice via prepaid registered mail, but the 50 pages of conduct rules and management rules they put on like Dropbox or on the scheme's website or something like that. Remember, the Act also says that any document that is going to be considered or voted upon has to form part of the notice, and that needs to be sent as well. So you are literally going to be posting out a Bible of the document, but that's the legal requirements for it. The quorum, we know for a special resolution, the quorum is 33.3%, like a normal resolution. And if you don't get the first meeting, you can go to the next meeting, the adjourned meeting. Obviously, you wait 30 minutes the first time around and you wait 30 minutes the second time around. But the second time around, whoever is at the meeting, provided that it's 2 or more, forms the quorum. When it comes to unanimous resolutions, and I think this was also a question on the group not too long ago, you cannot pass a unanimous resolution at a meeting of less than 80% quorum, both of persons present or represented by proxy. And that 80%, unfortunately, cannot be held over to the adjournment. In other words, if there's less than 80% at the adjournment, you still can't pass the unanimous resolution. I recently read minutes of a special general meeting. It was actually a first general meeting where the amendments to management rules were tabled for approval. They didn't have a quorum of 80%. I think they had like 40-odd%, obviously very, very far away. And because they didn't have a quorum, they decided to propose that the amended management rules actually be put into the conduct rules at the meeting. Luckily, 1 or 2 of the owners stood up and said, no, that definitely can't be done. So there's creative ways of trying to get around this whole unanimous resolution 80% quorum, but unfortunately, there really isn't a legal way of doing it. The Community Scheme Ombuds Service has recently published information to say that they will entertain, and we've known this, they will have a look at passing a special unanimous resolution on behalf of the body corporate that has not been able to, either because there's been unreasonable opposition or simply because they're not able to get a quorum through owner apathy, whatever it might be. But they've got thresholds in place. And I was trying, my memory might not serve me, but get it afterwards and we'll make it available, that the threshold is 75% for a unanimous resolution. In other words, legally you need 80%, but if you get 75% and approach the Community Scheme Ombuds Service, and I don't believe that is useful at all, because if you look at most of the minutes and most areas where unanimous resolution is not achieved, the quorums that you are looking at is 33.3%, 40%, 50%, maybe a bit more. To even reach 75% is not achievable at all. So that's something that I think the Community Scheme Ombuds Service needs to look at as well. All right. So that was the reference to the practice directive that we'll make available. My experience with the CSOS review and approval process has been both good and bad. I have a couple of bugbears. We know that the rules that are amended can only be enforced once the certificate of approval has been made available. They used to say that it needed to be the hard copy needed to be made available, in other words, the original, but they are emailing it out, and the moment you get that from the date of that approval, in other words, not the receipt of it, but the actual date that is on it, before then. And I've very often seen that there's been body corporates that have attempted to pass or deal with, or apply rather, amendments to conduct rules or management rules after the date of the special general meeting, before the certificate of approval has been provided to them. I have seen 1 or 2 instances where the Community Scheme Ombuds Service in writing has said the certificate is not yet available, but you can start applying the rules. That is not legal at all. The other thing that happens often is, completely slipped my mind now for a second. So it's a CSOS review and approval process. Those, amendments to the rules. So when the CSOS reviews rules, they often come back to you with a list of amendments. So for example, don't refer to the Sectional Titles Act, only refer to the Sectional Title Schemes Management Act, or you have anything about slaughtering or whatever it might be. If it is a non-material item, I've got no issue that the trustees amend those rules and submit them back to the Community Scheme Ombud Service again. But sometimes there are material changes that are needing to be made. In other words, rules need to be deleted or rules need to be added. That legally needs to go back to the members for a special unanimous resolution again. It's not something that the trustees can actually amend and apply. So in my experience, those are the types of things that I've dealt with. Again, I'd be very interested to hear what the attendees say about that. And then something else that Willie and I were talking about earlier is that the rules need to be obviously constitutional, which was the basis of my thesis. They need to be suitable to the specific scheme. If you have a mixed-use scheme, they need to be suitable. If you have a scheme for the retired persons, it needs to be suitable. They also need to be reasonable, and that goes in with the fining rule and the discussion that Willie had on that. And then, of course, they need to be applied equally. And something that we often deal with is the ground floor apartments can keep pets, or the ground floor apartments can have braais, but anybody from the first one up can't have pets or can't have braais. We can't have rules like that. Rules have to be applied equally across the board. So that's just a couple of points there. I don't know, Daniela, if there's some interesting questions you want to ask before we go on to the next one. Otherwise, I think this is the last slide. Perhaps we can deal with that. You're just on mute.
Hang on, I'm muted. Sorry. I just saw a question from Nicole to say, please, Zerlinda, can you go through the requirement for a unanimous resolution at an adjourned meeting slowly? I lost the thread.
I almost thought that was my Nicole for an example, but when for a second, but when you said slowly, I'm like, no, that's not Nicole. She's used to my fast speaking. Okay, so a unanimous resolution can be passed at a meeting, or it can be passed via round robin. If it's going to be passed at a meeting, you need an 80% quorum. That's at the original meeting or at the adjourned meeting. You always need an 80% quorum. Of that 80% quorum, 100% of members have to vote in favor. Now, a couple of years ago, I was asked the question, does that mean that it's 100% of 80%? Or 100% of whoever is at the meeting above the 80%. Because if there's one owner that comes to the meeting and he is the 85th percentile, does that mean we can ignore his vote and he does not need to vote in favor of it? It is a minimum of 100% of an 80% quorum, or 100% of whoever is at the meeting if it is more than 80%. If you do have more than 80% at your meeting, pat yourself on the back, because that's a job very, very, very well done. Normally, we don't reach that quorum at special general meetings or annual general meetings. So that's the quorum requirement of it. And then, of course, if it is via round robin, in other words, in writing, it's 100% of all of the owners, so 100% of 100%. So that's the requirement for unanimous resolution. Okay.
Thank you. There's a lot of questions that relate to this slide that you're going to be talking about now. So I'll wait until the end and then we can go through those.
Fantastic. So the first one I actually dealt with earlier, and that was the application. In other words, when does the rules apply? It applies from the certificate of approval. So in other words, the date of the certificate of approval. I can't actually remember what I thought about with the complaints. I actually need to start making my slides a little bit more meaty. I see a word and it makes complete sense when I'm drafting it, but not so much afterwards. When it comes to contraventions or complaints being made, so in other words, an owner complains about the behavior of another owner, we actually in our rules have a complaints process. And I know at my folk scheme, they've got a complaints box. How often that box actually gets emptied out, I don't know. It used to be a complaints book, but then the book used to get filled up too quickly. So they now have a complaints box. I'm sure there's a hole at the bottom of it and it goes straight into the dustbin that's below it, but in any event, a little bit of humor there. The complaint process is very important because you need to point out to owners that when they are going to complain about behavior or conduct in their sectional title scheme, that they need to to differentiate between matters that the trustees must get involved in and matters that the trustees do not get involved in. So if I'm going to complain about the neighbor, my neighbor above, because they come home at 3 o'clock in the morning with their high heels and they have a dance party and it keeps me awake, that's an owner-on-owner issue. But if there's a child in the complex and the child roller skates up and down the passage and affects 20 units, you know, that's a body corporate issue. And very often managing agents and the trustees get involved with or get forced to get involved with matters that should be dealt with between owner and owner, or tenant and tenant, or owner and tenant. So in our complaint process, we actually specify, you know, when is a complaint needing to be dealt with by the body corporate and when not. And I always tell my clients, don't get involved in a dispute where you don't have to get involved in other words, from a trustee or managing agent perspective. The community scheme ombuds service does require that every set of rules have an internal dispute resolution process, which is obviously not arbitration. Body corporate rules cannot provide for arbitration. Arbitration used to be in the prescribed management rules of the old Act before it was repealed. So an internal dispute resolution process can be as simple as getting invited to a meeting and dealing with, you know, a fine being raised, or it could be as simple as go and talk to your neighbor if your neighbor is making a noise. If that dispute resolution process has been undertaken but has failed, you can then make an application to the community scheme ombuds service. And now the biggest thing that we consult on is fines, and I'd be interested to hear from Willie from his perspective as dealing with collection so often, and probably more like disputes with fines and other amounts that have been raised on the account. You know, what would you consider to be the proper process and the right amount of the fines, bearing in mind the only thing that I want to say about this specific subject is that the community scheme ombuds service and their practice directive has said that the fine cannot exceed, rather Nicole remarked, be equal to or exceed a monthly levy. And I get questions as to whether or not that includes the CSOS contribution. Does it include, you know, the exclusive use area contribution? Does it include, you know, water and electricity? Is it the levy that is raised for the particular unit? Is it the levy that is raised the lowest in the scheme? Is it one fine per month, or is it like all the fines continuously for that period? I'd be interested, Willie, to hear your thoughts on that.
Zerlinda, luckily we have not had many problems with fines in the courts. Obviously, when we do our due diligence on a body corporate, we make sure that the rules make provision for fines. And what we have dealt with is that the fines, and what we normally do is we would exclude everything that exceeds the levy, the normal levy for the owner for that month. So we would not, if there were fines raised that exceeds the normal levy in a particular month, even if it was 5 or 10 contraventions, we would make sure that it's just that normal levy, and we would want the body corporate to remove everything else. And we've not had problems in courts then enforcing that. So that is in our process. So in our mind, I think our attitude is that this is your normal levy for the body corporate. This is what is payable to the body corporate. It is not all the extras, because there's lots of body corporate that charge their accounts or do their accounts in different ways. They've got their security as a separate issue. They've got their lots of different things, entrance, gym, different stuff, all different little amounts on there. So we would deal with it as the normal levy and not exceed that, and we've not had problems in collecting that then. So yeah, that's, I think we're just being prudent and being cautious by doing it in that way.
Willie, I see Sharon just posted a question on that topic. Our rules have been approved recently, I'm assuming by CSOS, and our limits exceed the levy. What would you say about that?
Sure. So I don't think that one can do that. Are we now contracting out of the Act? Because Zerlinda, where's the provision in respect of the amount of, or the maximum amount? Is that in your?
There isn't.
It just says that it must not exceed the levies. But is that in the?
It's a practice directive.
It's a practice directive.
It's one of those things that haven't been clarified by CSOS. So the wording is very open-ended.
Yeah, so then one would not have a problem, because I mean, if CSOS has approved it, then they've decided that they will allow this in this instance. So I think then you would be able to enforce it. So if the certificate is there, you can enforce that. Obviously, if it was in the Act, then the fact that they've approved it, the rules can't exceed or is not higher than the Act, and therefore you would not be able to do so. So if it's merely in the practice directive, then there's no problem with that, and it's approved. You can then charge as in accordance with what that allows you to charge. And you would not probably have a problem. You will have to explain it in a default judgment to the court. They will definitely raise a query as to how the amount has been calculated. And they will ask you about the process that was followed. Want to make sure that the audi alteram partem was followed, that it was not just put onto the person's account without him or her being able to dispute the amount. And trustees will have to be able to sign a document or an affidavit confirming that that was done in accordance with the rules, and then stipulate the rule for the court before they will allow it in a default judgment. So then it's not a problem, I would think.
Willie, what is your position on the ability of raising those fines on the levy account from a collection perspective? Because I know a lot of attorneys say that the fines must be raised on a separate account, not on the levy statement.
We have no problem with it being in the levy statement. I also see that what they do is they also raise the legal fees, the total legal fees, in a separate account as well. The question is who is liable to pay that, and on what basis can you raise a second account against a person? So from our point of view, we would want to see everything in the account, but then in accordance with the Act and in accordance with the rules. And we will make sure when we do our compliance to determine what we are prepared to pay to a body corporate, we would make sure that they are compliant with the Act and compliant with their own rules in that respect. And it doesn't matter that it's in one single account. I can't understand the second account thing, because who's liable for that second account? When will you be required to pay it? Will you be required to pay it? What is this? Why would you put it there? If you can't raise it against the owner, for example, legal fees, then the body corporate is liable for it. So to put it into a second account in the name of the owner serves no purpose at all, because at the end of the day, the body corporate as a whole will have to pay that. That's an expense for the body corporate.
Yeah. Just on what you mentioned, the audi alteram partem rule is the process thing. So this is the last point that I have, Daniela, before I hand over to you, is the CSOS is 100% fine with there being fines in a rule. Firstly, it must be at the end of the document. So very often when we review rules, each rule says, if you contravene this rule, you will be fined. If you contravene this rule, you will be fined. It's not necessary to say that. You need the fining provision at the end. And it's actually the very first set of amended conduct rules that I submitted to CSOS, which was my own sectional title scheme years ago, where the CSOS came back and said the fining will of the document. So in other words, it applies to the entire document, and there must be a due process. So there's been a warning, there's been an opportunity to come and review the fine prior or after it's been raised. And then, of course, something like, if the trustee is the owner that has been fined, that trustee needs to recuse themselves, because that's in the Act and the management rules in any event. Before I think we go back to Willie and Daniela, Nicole has allowed me to make the very kind offer to your clients, specifically Stratafin, that for the month of November this year, November 2021, if you contact us during the course of November to amend your conduct or your management rules or both sets of rules separately, we will offer you a discounted rate. You just need to use the code Stratafin rules, that we know that you were in attendance at today's meeting. And then, of course, we'll take you through that process. What we do is we review your current rules or your draft that you've worked on as trustees or with member inputs, any comments or questions that you might have, any annexures to your rules. We then put together a brand new set for you that are in compliance with the STSMA as well as the Community Scheme Ombud Service Practice Directives, the Constitution, all those fun things, but obviously specific to your scheme, because we send you a checklist where we ask you specific pertinent questions to your scheme. For example, do you have a swimming pool? Do you have a tennis court? Do you find? Do you do short-term letting, etc., etc.? And then once we've sent those to you in the Word format, so it's your document, it's not branded or anything those lines. All yours, you can keep it. We consult with you via Zoom or Microsoft Teams for an hour per set of rules, and we take you through those amendments. We talk to you about why we have to allow ritual slaughtering, etc., etc. After that meeting, we make amendments to the rules as we've discussed and agreed with you, and then we send you that final set of rules to send to the owners. We also make ourselves available after that process to either submit the rules to the CSOS or to actually deal with it at an AGM or an SGM, to take the members through it, to deal with their queries. So it's a whole part and parcel. It's a set fee, no extra charges and all that fun stuff. So you know what you're getting yourselves in for. And then, of course, if you are in attendance today, a discount will apply if you use that discount code. That's it.
Fantastic.
Perfect.
Thank you, Zerlinda. And I think that's an awesome offer that you're giving to the attendees today. I think they're going to, really find it helpful. So thank you for that. I'm just cognizant of the time. We have just hit 12 o'clock, so I don't want to take up any more time on the webinar, but there are tons of questions that have come in, and I'm so sorry if we haven't been able to get to them during the live Q&A. What I will do is I will share the questions that have been posed that we haven't been able to get to. I'll share them with Willie and to Zerlinda. And we will get back to you with the answers to those questions during the course of the day or tomorrow or whenever we can. There were a lot of questions, so as soon as we can, we'll get back to you on those.
Can I just quickly also say there were questions, or there was a question, Zerlinda's contact details. So obviously you can just click on the link on our website, and that will take you through to Zerlinda's business. Alternatively, Daniela will give those details so that you guys can get hold of Zerlinda. She's in Cape Town, but it doesn't matter where she sits. The world has become very small nowadays, so you can consult from anywhere. So definitely, she is one of our partners, so you can then just click there and it will take you straight through to her. Alternatively, Daniela will give those details.
I'll send all the details in an email along with the recording of today's webinar, along with Form B or the practice directive. All of those documents that we spoke about will be sent out in an email to everyone this afternoon.
Linda, I just want to say thank you so much for this. We've learned so much. As we said earlier on, I'm still busy with your master's thesis, so it's my reading on my desk here. So yeah, it was great listening to you and learning from you. It's awesome having you here.
You clearly need more clients to keep you busy, that you've got time to read my master's thesis. I was told by my supervisor to never ever read it again, because if I find a comma in the wrong place, or God forbid a missing comma, I will literally want to kill myself. So I don't look at it at all. But thank you so much to both you and Daniela for the opportunity. I've really enjoyed it, and you said that I could talk as much as I wanted to, and Vrachis, I did until 1 minute past 12.
Okay, thanks so much. We'll be jumping off shortly, but thank you very much, everyone, and enjoy the rest of your day.
Thank you.
Thanks, guys.
Thanks. Bye.